All right, so it looks like we got Lil Durk and his legal team responding to the government and the reasons for why he should not get bond. Right, I've been covering this on the channel, so you guys should be caught up. But if not, I'll give a quick run through. Durk was named in the original indictment that charged his co-conspirators with the murder of Lil Pab in LA in August of 2022. Durk wasn't charged in the original indictment, but he was listed as co-conspirator 1. After the feds arrested all of his co-conspirators, they then unsealed a superseding indictment against Lil Durk. In his superseding indictment, they use lyrics from a bunch of Lil Durk songs, but notably they use one example where they say that Lil Durk commercialized the death of Lil Pab by dropping a song that had Quando Rondo screaming no in a news clip after Lil Pab was shot. Lil Durk and his defense team responded to that. They said, hey, we don't know what the hell you guys are talking about. That song was recorded 7 or 8 months before Lil Pab was shot. There is absolutely no way that that song was about Lil Pab and Quando Rondo. On top of that, the no that was heard in the song was actually added by fan-made social media accounts to make the snippets of that song go viral. But Durk never released the song, and him and his engineers and producers never added that no. That was something that was added in post-production by fans. So they responded to the government saying, hey, Lil Durk needs bond because the government presented these lyrics to a grand jury in order to secure an indictment. Without those lyrics, who knows if they even could have indicted Lil Durk. So basically they were saying that the government used false evidence to secure that indictment. He submitted an application for bond reconsideration trying to get out. Since then, the government has doubled back. They have hit him with the second superseding indictment. And in this indictment, they exclude the lyrics that they used in the first grand jury hearing and say, even without the lyrics, we have enough evidence and information to charge Lil Durk. And they were able to secure a second grand jury indictment. With that, they said, we still don't believe that Lil Durk should be let out on bond. He was still on a flight when we arrested him. He was still trying to leave the country. He still paid using OTF credit cards to get his associates to California so that they could do this hit. And like I said, basically they secured a second superseding indictment against Lil Durk. And with that, they also submitted a motion for him to remain detained. Well, today we are getting Lil Durk's response. We got that right here. This is a reply in support of application for reconsideration of detention. Basically, this is Lil Durk's reasons for why he should be released on bond. His first motion for reconsideration largely relied on the fact that the government presented false song lyrics and evidence to the grand jury to get that indictment. So when the government filed that second superseding indictment excluding it, it basically requires Lil Durk to respond to them in this new superseding indictment. This is his response. It says defendant Durk Banks, through his attorneys, Drew Finley, Marissa Goldberg, Jonathan M. Brayman, and Chastity O'Connor, hereby files this reply in support of his application for reconsideration of the detention order in this matter. It then gets into the introduction. It says, on December 12, 2024, this court held a detention hearing and ultimately ordered that Lil Durk be detained based on 2 factors, danger and flight risk. On the issue of danger, the court relied primarily on facts presented in the first superseding indictment. The issue of flight risk, this court admitted, was a closer call. As the court is aware, the probation department assessed that Lil Durk was not a flight risk, but did recommend detention based on dangerousness, right? And this was a point of contention when the government responded to him the first time when he requested bail or bond in this situation. They said, despite the lyrics, we still think he's dangerous. He was still on a flight. We still think he was trying to leave the country. And to be fair, Lil Durk and his legal team in their first motion to reconsider bond really did not hit on the points of dangerousness and flight. They really did only hit on the lyrics that were used to get the first superseding indictment. That's why the government doubled back and hit him with the second one that excluded those lyrics. So it says, since that hearing, the landscape has shifted. On May 1st, 2025, the government filed a second superseding indictment, which removed 2 major allegations from the first superseding indictment. First, it removed the allegation that Lil Durk's song lyrics somehow glorified the murder of Savia Robinson. And second, it removed the allegation that Lil Durk directed others to pay or be paid a bounty for the murder. Importantly, the government returned to the grand jury and sought this second superseding indictment after, and apparently in response to, Lil Durk filing his motion to dismiss the indictment and his application for reconsideration of the detention order. In essence, the government effectively conceded Lil Durk's central argument in his application for reconsideration that the the government presented false or misleading information about Lil Durk to the grand jury and to this court concerning critical factual allegations. In its response and supplemental filing, the government downplays these charges as immaterial and undeserving of this court's consideration. However, as detailed below, they are both appropriate and of great import in this court's review of the statutory factors for release. With the issues of the lyrics and the payout of a bounty altogether abandoned, what remains of the indictment is a weak patchwork of unsupported and non-specific allegations against Lil Durk. This watered down new indictment, coupled with the robust bond package proposed here, tips the balance in favor of Lil Durk's release pending trial. So then they get into the argument. It says the weight of the evidence has changed since the initial detention order. 18 U.S.C. 3142 requires that the court look at the weight of the evidence against a person to determine whether there are conditions of release that will reasonably assure the appearance of a person as required and the safety of any other person in the community. With the new indictment in mind, the alleged weight of the evidence against Lil Durk is significantly weaker, and I've got to agree with his attorneys right here. Them removing from the indictment the bounty that Lil Durk supposedly paid to people for this hit was significant. Them removing the song lyrics where they say he capitalized and commercialized the death of Lil Pap was removed, and that does make the case weaker. However, there are still some things that are in the second superseding indictment, like the fact that he paid for the flights of his associates to get to California, and the fact that they are in fact the ones that did kill Lil Pap, and the fact that they have surveillance footage of Lil Durk's homies who he paid to go to California following Quando Rondo around in their SUV before this all went down, is still pretty heavy evidence, but the case is a little bit weaker because of that. It says, first, the second superseding indictment removed paragraph 6 of the introductory allegations in the first superseding indictment, which relied on lyrics from a song to allege that Lil Durk was somehow celebrating or commercially glorifying the death of Savaya Robinson. This was a hotly contested issue at the detention hearing. With the second superseding indictment, the government has now conceded the issue entirely, despite the fact that it took up a significant portion of the detention hearing. To be clear, the inclusion of the now removed portion referencing song lyrics was more than immaterial fluff in the first superseding indictment. The government absolutely intended that section to illustrate direct involvement in the alleged murder for hire, and more importantly, the knowledge of Lil Durk of the alleged offenses through some sort of musical confession. The government has now been proven wrong and has removed the reference, substantially depreciating the weight of the allegations. Of equal or greater import, the second superseding indictment removed paragraph 9 of the original indictment, which alleged that Lil Durk directed others to pay a bounty for the killing of Savaya Robinson. And that's Lil Pap. I keep saying his full name, but it's Lil Pap. This material change also significantly impacts the court's calculation, as this court in the initial detention hearing specifically cited the government's allegation that Durk exercised control of others and that other people acted at his direction to find dangerousness. And they did do that in the initial detention hearing. They got a quote here that says, although the allegations are not that the defendant personally pulled the trigger, the allegations are that the defendant exercised a significant amount of control over other individuals and that those individuals were acting at his direction. That is what the first indictment said. It says, now, with the payment of the bounty allegation withdrawn from the indictment, the foundation for this court's conclusions has been materially undercut. Outside of the allegations in the new indictment, the government can only point to ambiguous or insubstantial pieces of quote-unquote evidence, i.e. the one singular text message subject to a variety of interpretations alleged to have been sent by Lil Durk. And they're talking about where he said, don't book no flights that have nothing to do with me or my name. It says no other specific or direct evidence has been provided to date, including any evidence showing Lil Durk's alleged control of others the government continually refers to in previous indictments and in their arguments before this court. The bulk of the government's contentions include its own proffered generalizations that seemingly come from an informant whose veracity and credibility has never been subject to challenge to support the false notion that Lil Durk is or ever has been a danger. While it is true that the second superseding indictment also added an additional charge of stalking, and they added that because remember they have footage of Lil Durk's homies following Quando Rondo and Lil Pap around the city before they pretty much executed this hit. It says the addition is immaterial to the question of detention as the allegation already existed in the first superseding indictment. No new allegations are contained contained in the stalking charge of the second superseding indictment. It's got subsection B, reasonable conditions exist to secure the safety of the community and to assuage any concern regarding risk of flight. Lil Durk has filed a robust bond package which outlines a variety of conditions to secure the safety of the community and ensure that Lil Durk complies with all conditions imposed by this court. One of the conditions that Lil Durk proposed was the use of 24/7 licensed security. This court expressed concern that the presence of a security company providing security for the defendant is not going to address the significant concerns with regard to the safety of the community here, because the security company would be acting at the direction or under the guidance of the defendant. The government argued that the security would be present for the physical protection of Lil Durk. To clarify, the purpose of the security company, detailed in this bond package, would be to enforce the terms and conditions of the bond set by this court. Specifically, if there is an order regarding curfew or home confinement, the security company would serve as a prophylactic measure to ensure Lil Durk's compliance with those conditions. Put another way, the security company would be beholden to this court, not Lil Durk, though he would be the one footing the bill. Both Lil Durk and the security company are well aware of this agreement and will provide a specific plan regarding the line of communication to the court and or to pretrial services if the court allows release. And this is something that the judge hit on the first time when Lil Durk requested bond. He basically said, look, y'all offered 24/7 security, but Lil Durk is going to be paying that security company. That means that the security company works for Lil Durk. They really don't have a reason to enforce what the court says. Lil Durk's attorneys here is trying to clarify that if pretrial services makes some kind of order with the court where the security company has to be held accountable by the court, then that would mitigate the concerns that the judge was having. It says, with this check in place, Lil Durk poses no danger to the community or fleeing the jurisdiction, as non-compliance would trigger the immediate alert of the court, right? So they really didn't hit on why he's not a flight risk. And I said this in my previous videos. The government is alleging that Lil Durk booked flights to leave the country after he learned that his co-conspirators were being arrested. I think the best way to prove that Lil Durk isn't a flight risk and wasn't trying to flee because of that is to simply provide receipts of when he booked those flights. If he booked those flights before his co-conspirators were arrested, then it would be hard for the government to say that he was trying to flee because of that. However, they haven't provided those receipts. They haven't offered that as an explanation, which leads me to believe maybe Lil Durk did book those flights after his co-conspirators started to get arrested. I really feel like they should have hit more on that in this specific motion for bond reconsideration, as if they can prove that he booked the flights before everybody was arrested, that would significantly reduce the risk that the court sees when it comes to Lil Durk fleeing. But hey, man, what do I know? They then have the conclusion. It says, wherefore, based on the change of circumstances created by the second superseding indictment, as well as the significant bond package that includes stringent conditions that would properly rebut the presumption that he is a danger or a flight risk, Lil Durk respectfully requests that this court release him on conditions pending trial. And they're basically arguing in this motion to reconsider that, look, y'all think I'm a flight risk, y'all think I'm a danger. Let's get a security company that will keep me in check and will report directly to the court or directly to pretrial services. And if I try to do anything or try to flee, then the court can be immediately alerted and Lil Durk can be held accountable. I do think this is a solid motion that was written right here by Drew Finley. They do bring up the point, that the first superseding indictment was kind of secured based on a false premise, but that really doesn't matter because the government was able to go back and secure a second superseding indictment without any of that information that was in the first superseding indictment, meaning that they could have indicted Lil Durk even if they didn't have that in there. We know because they were able to secure that second superseding indictment. Hitting on that does kind of undermine what the government is doing, and it does make them look a little bit incompetent. However, I'm going to be real. I don't think that they provided enough in this motion for the judge to change his mind. I remember the judge's response to the first motion to reconsider bond, and he basically wasn't hearing none of that shit, right? Bro is definitely not a rap fan. He pretty much seen the bond package that Lil Durk proposed and was like, nah, fuck all that. I ain't hearing none of that, bro. You're staying in jail. I don't think that this motion right here is going to change that much. I think it could have if they had coupled, the security company argument with receipts showing that Lil Durk wasn't trying to flee when they caught him on that plane. But they provided no evidence that he wasn't trying to flee. And I think that that is going to be what stops Lil Durk from getting bond. But at the end of the day, nobody can predict the future. Nobody really knows what the judge is going to conclude when it comes to this. He very well could feel like there is a miscarriage of justice happening here because of the way that the government got that first indictment, and he may grant Lil Durk a little bit of leniency because of that. It's just my personal opinion that he is probably not going to, but hey, we're gonna have to wait and see. For now, that's what we got. That's Lil Durk's official response to the second superseding indictment and to the government wanting him to remain detained. And like I said, only time will tell where it goes from here, but y'all gotta let me know what y'all think about this in the comments down below, because that is basically it for the video. If you guys enjoyed the content, be sure to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. As always, it's been fun rocking with y'all, man.